well. Thank you for your forbearance.
Mr. Speaker.
I call the Honourable Rick Barker.
Mr. Speaker, the National Party has castigated the opposition on a number of occasions, I think unjustly, about the way in which it uses parliamentary procedures to oppose legislation. And I want to make the point to the House that the opposition's role is to oppose bad legislation. And we will. And we'll do it with all the power and the force that the standing orders provide. And there should be no criticism of that. And I want to reiterate, following on from that, the point made by Charles Chauvel, that what we are embarking upon here is no small matter. The government has asked for standing orders to be suspended. That's what they've asked for, the suspension of the rules. And this is not ever done lightly. The Minister has come with a well-argued case and his staff. John McIntyre has argued the case for the government very well. And it was only on the basis of the merits of the case that we have agreed to suspend standing orders. It is not something done lightly, Mr. Speaker, as you would well know. And we've done so because we do agree with the intent and the thrust of the amendments that the Minister wishes to bring to the House. And I want to put it into simple language. The fact of the matter is that for a long time, our court system, the administration of it, had been overlooked by the legislature. The legislation is old, it's antiquated, and one of the pieces of legislation which is relied upon and amended many times is the Judicature Act 1908. Well, I don't know many other parts of our society where the foundation bedrock of it is a piece of legislation passed in 1908 and amended. It's well overdue overhaul. When I was the Minister for Courts, I suggested to the Ministry of Justice that we overhaul the Judicature Act 1908 and update it, and they almost passed out at the prospect of such a huge piece of work. But it is a bedrock on which our system rests. It is very old. There are many other pieces of legislation which are very old, and they date from a time when each of the courts saw themselves as separate entities. The High Court, with its inherent jurisdiction, the District Court, and they all had their separate processes. And not one of them had anything to do with the other. This, of course, was the approach that the judiciary took to it. But it is not the approach that the public take. The public see the court system there as an entity, just simply different doors to the same house. And they believe that when they owe money to a court, they owe money to the state effectively. But as far as the judicial system was concerned, if a person owed money via the tribunal system, it was different from owing money to the district court, which is different from owing money to the High Court. And not that long ago, each court had to have its own process of taking the money that people owed them. Now, a bailiff or registrar could not, for the district court, enact matters on behalf of the High Court, nor could they on behalf of a tribunal. Now, the general public would have seen this as pretty impractical, and it was, and it is. Money that people owe is money that they owe to the court system and to the state and to the victims if it is reparation. In essence, what this piece of legislation proposed by the Minister does is to simply streamline that and to help treat any debt, any amount that's owed to a court, to be able to be picked up and dealt with by the same process and by the same system. Whether it be reparation in any form that is given, whether it be a fine in any form that is given, with any jurisdiction, and with any matter that's owed. And that all the tools that are available in one jurisdiction will be available to all. That if there is to be an attachment order for a fines owed for the district court, and if a person owes money to the High Court, the District Court and the Tribunal, a single attachment order will cover all three. That's as I understand this piece, this SOP. Now, that is eminently sensible, and anyone would agree with that I think even the people who owe the money to the court system would agree with that too. Now, one begs the question as to why we have to suspend standing orders in order to get this sensible piece of legislation through. Well, I want to make the point to this House and to anybody else who wishes to listen, that one of the great frustrations I had when I held the portfolio that the current Minister does, the Honourable Georgina Te is that when these ideas come up, it takes quite a lot of work and effort by people in the back rooms, the back office, the policymakers, to ensure that the legislation is right. Because there are many different pieces of intersecting legislation. And if the legislature passes the legislation incorrectly, it becomes almost impossible for the courts to fix. Well, in fact, they can't. And it becomes almost impossible for them to operate. So in making these changes, people have to be very, very careful. They have to be very skilled and very knowledgeable, and it's not work that is rushed. So I can well understand how the Minister has got this out of sequence and out of time. But the point I wish to make is, in all this hubris that we get about reducing the state sector, about shifting people from the back office to the front office, and cutting down on civil servants who are somehow portrayed currently in this current atmosphere as a dead weight loss on the public, that we are only going to exacerbate this problem. The one thing that I felt I lacked in the executive arm of government was the necessary resource to do the policy work, to do the theoretical work, to bring the papers forward, to get the legislation prepared, checked and drafted, to pass it. This should have been passed 3 or 4 years ago. There are other matters associated with this which should have been passed 5 or 6 years ago. And I make no criticism whatsoever of the people who work in the Ministry of Justice today, who work for me, about the slowness of it. There is only so much people can do in a particular day. And if we want this stuff, this type of legislation to be passed, then we simply have to put the time and the resource into it, and that means to engage, hire, employ, and have the civil servants with the skills and the capacity to develop the policy, to write the papers, to write the legislation for us. Now, unless we are prepared to commit to that, then the reform of our judicial processes, which is well behind where it should be, will continue to drag on. And the only sufferers of this will be the people who either use it willingly or reluctantly. And I want to make a couple of points about the reform. Anybody who goes to a local courthouse on a Monday morning will see a great big queue of people standing outside waiting to be heard. We'll all be told to turn up at 10 o'clock. And then they're processed in some haphazard order, but no one knows when they're. They could be there at 2 or 3 o'clock. I don't know of any other part of the state that does it this way. Imagine if a hospital said, we're going to do hip operations, everybody turn up on Monday. But have queues everywhere. And they would then wait to see when the doctor was at camp and camp and camp. Of course the health system doesn't do that. They give people a date and a time to come and see the specialist. And we turn up on an orderly queue. We are treated in a civilised manner. But in the court system, you're simply told to wait and wait and wait. This is out of date. It's antediluvian. We also have a lot of other things that need to be done, such as electronic filing of courts. We have to do a lot more work, and this requires a lot more policy. And I want to re-emphasise the point made by Charles Chauvel, that the overhaul of the administration of our justice system lags well behind. And Charles makes a very good point that we've got a change in people. The Honourable Simon McPower, Georgina Te the Secretary of Justice, and it seems to us that the system, in an hour of time, when it needs to be overhauled and have strength and direction, has in fact had a complete change of the guard. And it seems to us that this is simply going to exacerbate the problem. And we are going to be faced with more situations where this type of amendment, worthy, justified and supported by the opposition, is going to come to this House in an inappropriate way. No criticism of the staff who bring the work together. It's a criticism of the structures and the resource that aren't there to do the job properly. We will continue to suffer from this until it is well managed. And so, Mr. Speaker, Labor will support this, the suspension of standing orders. We will support the motion for it to be put before the committee, and we will in all probability support the legislation when it comes before the floor of the House. Thank you.
I call the